Everyone. I'm going to call this meeting to order. Welcome to meeting number 41 of the House of Commons Standing Committee on Access to Information, Privacy and Ethics. Today's meeting is taking place in a hybrid format pursuant to the House Order of June 23, 2022, and therefore members can attend in person in the room and remotely using the Zoom application. Should any technical challenges arise, please advise me. Please note that we may need to suspend for a few minutes as we need to ensure that all members are able to participate fully. And pursuant to Standing Order 1083 and the motion adopted by the committee on Monday, May 16, 2022, the committee is resuming its study of access to information and privacy systems. I would like, Mr. Villemure.
Have the witnesses been tested for the sound on Zoom? Madam Clerk? We only have one witness today and he is in the room, so no need for sound tests today. Thank you for that, Mr. Villemure.
Call and welcome our witness today, Michel W. Drapeau, Professor, Faculty of Law at the University of Ottawa. The floor is yours, Monsieur Drapeau, for a 5-minute opening statement, and then we'll follow that with questions and answers. Monsieur Drapeau.
Thank you for having me. As a published author of an annotated legal text on access to information for the past 20 years, and as a frequent user under the access of information regime for the past 30 years, I've come across every frustration possible. However, today, I believe we have reached a new level. The right of access is now without a destiny, as it no longer serves its intended purposes. Fortunately, there are some solutions at hand. I've covered some of those in an article I wrote recently, which was published by the Mackenzie-Laurie Institute. For the
right to know to have meaning, timing is everything. It is not only crucial, it is the single most important factor in ensuring that the electorate has meaningful access to the information contained in government records. Promises of transparency and accountability in public administration are only meaningful if timely access to records can be guaranteed.
Today, the access process is increasingly bogged down in impermissible long delays, not so much at the federal institution level, but at the Office of the Information Commissioner, whose sole purpose in life is to investigate complaints involving a possible contravention of the Act. Let me explain. Years in, approximately 70% of the access requests are closed within the legislated timelines by federal institution, and this includes extension. So that part of the ship is not yet at a critical level, far from it. However, at the Office of the Information Commissioner level, it is not unusual to wait a minimum of 2 years for them to complete their investigation of a complaint. To illustrate, let me give you 3 examples experienced by my own law office during this month, October. Over the past 3 weeks, my office received results from the Office of the Information Commissioner for a complaint filed in 2012. And then another one concerning a complaint filed in 2018. During the same period, an OIC investigator advised us that she had just now been assigned to investigate one of our refusal complaints that had been filed in 2020. By the time that investigation is completed, we would have been waiting well over 2 years to get the results and maybe to get some records. These are not isolated cases. They are typical of the response being experienced with our complaints.
Such delays are unacceptable because they cause serious harm to users who have no recourse but to wait. Since the law stipulates that the Office of the Information Commissioner must first publish its investigation report before the complainant can file a complaint with the federal court. Fortunately, the time it takes to be heard by the federal court is measured in months and not in years, like the Information Commissioner's office.
there is an urgent need to have the Auditor General conduct a system-wide audit to ascertain whether there are sufficient resources, both at the Office of the Information Commissioner and at the federal institution level, to respond in a timely manner to users exercising the right of access. In the 39 years since the access regime has been enacted, there has never been any such audit of a system that consumes $90 million a year. First, the Information Office. The office is currently funded with a staff of 93 to accomplish a single task, the investigation of complaint. To perform that task, its senior leadership team is currently composed of 1 commissioner, 3 assistant commissioners, 5 senior executives at the EX level. This is 1 senior executive for every 10 employees. This seems to be particularly a top-heavy organization. Further, more than 50% of the allotted personnel of the Office of the Information Commissioner are employed in leadership, management, legal, public affairs function, leaving only 40 investigators to handle complaints. So there's no reason as to why we're waiting so long. Separate and apart from a system audit, I think there's a need also to consider whether the OIC should be subject to a time limit to respond to a complaint. In my estimation, I propose a 1-year limit by which the OIC should submit a decision. Second, there is a need for the Auditor General to review whether each of the federal institutions are properly staffed to undertake the volume of requests. Additionally, there is a need to revisit the current 30 days calendar. My proposition is to modify the Act to enable federal institutions to respond within 30 business days as opposed to 30 calendar days. This might significantly improve the performance level of institutions. We're waiting in any event 45 days and more to get response to a single request. So why not adjust the time factor to make it more convenient and sort of more realistic? So having said that, I'd be happy to respond to your questions, to any of my recommendations.
Thank you, Mr. Drapeau, and we did allow for a little extra time during your testimony. You're the only witness for this session, so we wanted to hear what you had to say, so I appreciate that, sir. Thank you. We're going to go to a 6-minute round first. Mr. Couric, you're up. Thank you.
Thank you very much, and thank you to the witness for joining us here today, and also, if I could note, thank you for your service to our country in the armed forces, and I know the work that you do in your law practice is unique in this country. So thank you. Thank you for that. You know, access to information is fundamental to democracy and accountable government. And on October 17th, the Macdonald-Laurier Institute published an article that you wrote entitled "Access to Information: A Quasi-Constitutional Right in Peril." You listed 6 steps for ATIP reform, 3 of which you believe can be implemented immediately. I'd like to give you the opportunity to expand on those 6 as quickly as possible, because I know time is limited, but specifically those 3 that could be implemented immediately.
Well, thank you. The first one is, last year, 52% of the access requests were directed to Immigration and Refugees Citizenship Canada. And it was an explosion of requests that I'd never seen before. 145,000 directed that particular department. I think it'd be fair to say it's a bit of an abusive process. Access requests are not designed to provide records or access to records to applicants for immigrations and so on and so forth. They are a less complex, less busy, less procedural system that could respond to their needs to have access to their records. And that will unburden the access regime. So if we go back 2 years ago, use that as a typical years, then I think the system is reasonably equipped to deal with it. Last year was a was unprecedented.
Sorry.
It also resulted.
Sorry, if I could, just my understanding of the system is the RCMP faced a similar challenge when it came to a change in administrative process regarding records as well. Is that?
It did, but not to the same extent.
Okay.
And at the same time, the Information Commissioner received 10,000 complaints as opposed to 5 and 6 they would have in a normal year.
Right.
So you have a system that is bogged down at the federal institution level
Right.
and the OIC. And last year was a disaster year, and it basically all odds were off. So if you can take 52% of the requests and to use a more administrative friendly request that doesn't have the kind of impediment, the kind of restrictions, and the kind of exemption the Access Act has, that will bring it down to a more measurable level, something we can do. So that's my first recommendation, that we can do this, and I think there are work on the way at the moment to develop an alternate approach within that particular department. So they should be pressed on to do that. My second recommendation, I'm trying to go quickly through them, is to get the Auditor General to do a report. Each department basically begs for assistance, each ATIP section within a given department, to the deputy ministers in order to get a sufficient number of resources to meet the volume of requests that they get year in, year out. In some cases, they're successful. In other cases, they have to line up because the department is short of resources. We have absolutely no idea at the collective level, certainly this committee, or even the OIC, as to what is the fair number of and the type of people we need at each institution to handle the volume that we have. It's through time we've come up with it, but some department, I'm using RCMP as a good case in point, they're grossly understaffed. As a result of it, when we try to get as a user, try to get access to records in the pursuit, to say, a litigation or in the pursuit of interest that the clients come to us, we have to line up for months and sometimes for years before we have it. And if we get ahead of the queue, we're only misplacing the problem someplace else. So I think the Auditor General ought to do a review, a system audit, to see whether or not we have adequate number of people and what is that number. Before we can impose upon each one of those ATIP coordinators the type of criticism we see in annual reports and sometimes in the media and so on, that they're not doing the job. I think they're doing as good of a job as they can be permitted to do with the personnel that they have. As I said, 70% of the requests are responded to within the established deadlines. The third point is user fees. At the moment, one pays $5 to submit a request. $5 has been instituted back in 1983. In today's values, that's $15. And to me, to spend $90 million of public funds on this request without any contribution from the users is kind of passé. I, as a frequent user, don't mind paying because I'm getting a service for free at the moment. Not only am I getting a service for free, but in 2015, the then government, in fact, made access regime much more friendlier than it was. At the time, before 2015, you had to pay so much if your request generated more than 5 hours access search time, if you had to pay for photocopying fees.
I apologize.
Go to 20 seconds,
I'm basically out of time. So if I can make a request that you submit that article to this committee, because I know it does unpack some of those things as well, and I look forward to the other questions. But if you would be willing to submit that information, I think it would be very, very helpful, because I am out of time. That's the challenge we face here. So thank you.
Thank you, Mr. Couric. Next round will go to Ms. Khalid for 6 minutes. Vikra?
Thank you very much, Chair, and thank you, Monsieur Drapeau, for being here today. We really appreciate it. I'll continue down the path of what you were just talking about with respect to user fees. Now, in 2016, you had stated that you don't believe that there should be any fees, but now you're saying that there should be, the fees should be adjusted to the cost of inflation. Can you help us understand how you got to that conclusion from where you were in 2016?
Purely from a practical perspective, I'm in a business of law. I have deadlines that are facing anytime we have to go to court and to have to make a pleading. I use access on a regular basis in the pursuit of our files, whether they're military or veterans or whatever. So I depend on it. I have a quasi-constitutional right to have it. But as I said, that right is in peril. I'm not getting any results. I'm getting not only not getting the records I'm after, but if I were to make a complaint, I have to line up for 2 years or 4 years or 6 years. So the system is so by having a fee, it's un genre de ticket modérateur that perhaps people or those committed to use the Access Act for their own personal needs will be prepared to pay a minimum fee, and that will, in fact, increase the possibility of be they deputy ministers or whatever, to increase the staff to respond to it, because it is a public service. Most provinces charge a fees, and it's in excess, in fact, of what I'm proposing. And I, as a business, even propose that we could be charged a little bit higher fees if for no other reason to accelerate the process, no other reason to respond truly to what is a quasi-constitutional right. At the moment, it's not. And I don't, Christmas is upon us soonly. I don't expect that the staff in a federal institution or the Information Commission will double overnight. It won't happen. So one of the ways to do it is perhaps have it user pay for some of the service. Some of the service it is nowhere near 90 million, but it's going to be discipline the process and at the same time provide some welcome financial relief in these days.
Thanks very much. So just kind of continuing on that, you did mention the ever-increasing number of requests for information that you're receiving. Now, how many of those requests for information do you believe are vexatious or frivolous that are clogging up the system? I know Mr. Couric has said before that he's put forward 300 requests for information. How does that equate into how effective your office is?
I don't know. I frankly don't know. I mean, the Information Commissioner may know. Up until the recent amendment to the Act, one could not qualify any of the requests as vexatious. The court, the Federal Court and the Federal Court of Appeal have long ago declared that the motive of the requester is immaterial. So regardless what his motive or frequency of it, you had to respond. So that has been disciplined from the last time the Act was amended. I think it can be disciplined more for the benefit of the user community that use it for a practical, honorable purpose by having a fee. That's my approach to it.
And you think that increasing the fee would limit some of those vexatious claims? And also, what is the impact of having an online button now where people can file their claims online? How is that impacting the number of claims that we're receiving?
I don't know. The Information Commission should be able to answer that.
Okay. So you had mentioned just in your opening remarks, I missed the number. I thought I heard about 60% of the claims come in from IRCC, from immigration.
Ask your question again.
I think you had mentioned this in your opening remarks that about 60% of the total that you receive come from the Immigration Department. Is that correct?
It's 52%. That's
52%.
Right. This year, and this year only.
Right.
Requests that were submitted to that particular department.
And do you think that there's a correlation between the number of requests you get per department and the, I guess, the delays or the backlogs within service delivery within that department?
I don't think so. I think historically, for the past 30 years, more than 30 years, the department that received the highest numbers, they tend to be the same one year to the next. CRE is one, the Department of National Defense is another, RCMP is another. Those departments tend to rank within the first 5. And I don't think that the climate or the public issues have had a dramatic impact upon the volume of requests received by each one of these departments.
So just lastly, Mr. Chair, if I do still have time. Thank you. So you've mentioned that you've wanted more oversight over the access to information system, and now you're appearing before our committee today to help us in reviewing the system as it is. Are there any very specific recommendations that you think are your top priority that should dominate how we frame this report?
Right from the get-go, we decided, we as a country, after a white paper on access, that the way to go was to have an information commissioner. We did not need to do this. The white paper had other options. In the States, for instance, you don't. You put in a request to an agency, and if you're not happy with it, you complain to the agency. If you're not happy with the complaint, you go to federal court. In Canada, we had an ombudsman type of style with the Information Commissioner, who was designed with basically three roles. First one is to investigate complaint. Second, to monitor what and to monitor and enforce the act upon the various federal institutions. And thirdly, to report to Parliament. But its primary task and its only role is to investigate complaint. Now, we find years after, over the past decade or so, it has grown so top-heavy that we only have less than 50% of its staff investigates complaints. Yes. 40 out of the 93 people. And when we find 4 commissioners, pardon me, do we need 4 commissioners and 5 executive and so on? All of that is at the expense of the sole function is to investigate complaint, and that's what I want. If a department doesn't give me or exempt or excludes information and records, my only avenue is to go to the Information Commissioner. I'm in the business of law. If I don't get an answer from that, then I have the ability to go to the federal court and get the federal court to adjudicate my request, except I have to wait until the Information Commissioner issues a report. Merci. At the moment, I have to wait 4 years, 6 years, 8 years. So it's killing us if we need to have access to these records through the only legal but quasi-constitutional mode, which is the access regime.
I didn't want to stop you, Mr. Drapeau, because you were on a roll there, but we are over time on this round of questioning. La prochaine ronde de questions, Monsieur Villemort de la Bloc québécois. 6 minutes, Monsieur Villemort.
6 minutes for Mr. Villeneuve. Thank you, Mr. Drapeau, for being here today. On October 5th, I asked the Access to Information Commissioner whether there was a culture of secret within the government, or on the contrary, whether there was the culture was one of openness. And they answered that the public servants always have trouble deciding what they can say or publish or not. What do you think? Well, I think we have a culture of secrecy. But I think this is typical of any public servant. We always ask them to protect information and to only provide it to people who are authorized to know. And so that's what they do as part of their daily work. They protect the interests of the Crown. That is their job as public servants. So when they are asked to divulge information, the Act provides 13 exemptions to protect what needs to be protected, and sometimes out of sheer habit, they'll say that something that is personal or confidential cannot be released, and that's where the commissioner's role comes in. Sometimes when you read this information, you can see that perhaps some information should have been made public, and that the commissioner could have released a decision that might have satisfied the applicant. So in the United States, and their situation is different. They have a report that says overall the public servants prefer not to divulge information in order to protect themselves. Is the situation the same here in Canada? I think basically yes, but the Access to Information team within each department has the experience, the duty, and to not just obey the law, but also to satisfy the applicant, for the person who requests information. Sometimes they think that if they can tweak information or tweak documents, they can provide it a little quicker. But each ministerial or departmental access to information group has a role to play in this respect. Now let's talk about the ASF, Border Services Agency, the RCMP, and the third department. Oh, do you think their access to information control is stronger than that of other departments? I do not know. In what context can the government invoke national security with regards to public contracts? Well, in all sorts of contexts, and I'm not an expert in public security, but it depends on which contract, what it's for, what the circumstances are. In some circumstances, it might be of interest to not disclose the total amount, the contractor, the scope of the contract. It just depends. Every contract is unique. But what do you think is a typical justification? Well, some contracts are top secret, but for any other type of contract, do you think there are some motives that are more valid than others? Yes, the Access to Information Act has 3 exceptions that I mentioned. One of them is national security, and it is interpreted in various ways. There's confidence, cabinet confidences, personal information. So anything that comes close to public security, well, I imagine that all public servants will be very prudent and will act conservatively and only release what is possible, practical and useful, and legal. What we call the need-to-know basis? Yes. Yes, and furthermore, the legal need to know. Within the law, of course. Well, how about a little example here? When we rent a property close to the border and we buy, for example, campers to park them near the border, is this national security? Well, no, it depends. It depends what these campers or RVs are being used for. You mentioned the delays in providing information. Do you think that the commissioner has the tools they need? Do they just need more money, or is it just a question of priorities and organization? No, I don't think it's a problem with their budget. Their budget is pretty generous, but my approach is simple. When less than 50% of the staff actually do the work they're supposed to be doing, that is to investigate complaints, that shows that there's a problem. Let's fix that problem first. And second, to hand it to the commissioner. I don't think that the commissioner can decide what their own resources should be. What we need is an outside agency, which is the a general auditor who can then assess the complaints and decide which ones are justified and perhaps see whether there's a better way of doing things. But the Auditor General is an expert in this matter, and they should be deciding such things.
Mr. Green from the NDP for 6 minutes. Matthew, you have the floor.
Thank you very much, Mr. Chair, and welcome to committee, by the way, I should say, in your first official capacity. Sir, through you to the witness has raised some, I think, very important questions. I'd like to explore perhaps the difference between what the causation, the correlation is with some of the inconsistencies and inefficiencies that he's identified with the entire process. And he referenced specifically just the sheer volume through the immigration cases. And I would ask through you, Mr. Chair, to the witness, if he would care to comment on whether or not he sees a correlation between failures in specific ministries to adequately address basic public inquiry with the rise in the rate of ATIPs. In short, is this a failure of a ministerial department which is causing the ATIPs, or is there another theory that he's had given his overview of the?
I'm not equipped to answer this question because I don't have the statistic for each one of the department and as opposed to their performance level in any given year, so I cannot address that. Okay. And even if I did, I'd be very...
But it was acknowledged that, in your opinion, the managerial staff is top-heavy. The operational staff needs to be, that complement needs to be more vigorous and complete in terms of its full-time equivalence.
Yeah.
In order to, yeah.
I have no hesitation. No hesitation at the office. I'm sorry. No hesitation to answer your question at the office of the Information Commissioner. These figures are public. At each one of the federal institution, I would need more data before I can pronounce myself, data which I don't have.
And so even within the existing budget, in theory, without allocating more money, there's an opportunity there to have increased people actively involved in the process. I want to talk a little bit around the technical aspects. One of my biggest frustrations, and I'm sure members on committee can share this, is when you get scanned PDFs back that are unsearchable. and part of the unsearchability of the way in which we collect data. And Mr. Chair, you'll recall this Liberal government had a minister of digital government that just disappeared. Would the member care to comment on when big data is released to him and his clients? Is there a difficulty as well in being able to find the information accurately given the way in which it's scanned rather than it being searchable PDFs?
If that question is for me, normally in the type of request we put in, we would indicate whether or not we want to have the records electronically or sent by regular mail. If it is sent by CD-ROMs, and we have a number of them, the Act provides that the information coordinator inside each one of the department or federal institution has a duty to assist. So it belongs to you to make your requirements known, and it belongs to them to make sure they do whatever is necessary to answer your requirements. We use
yes, no, I'm familiar with that. I guess what I'm trying to get at is that one of the things that we hear at this committee often around this is that the information, it needs to be digitized, and it's hard to find. And I'm just wondering if maybe that there are some system level failures. But it sounds like maybe I'll move on to my next question, and that's something perhaps for the actual department and the commissioner. You stated in your commentary titled "Access to Information: A Quasi-Constitutional Right in Peril" that your reforms include the service fees, fee for service. Wouldn't this change create greater barriers to individuals making the ATI requests, given that it's constitutional or a quasi-constitutional right?
At the moment, for an information coordinator in a given department to waive fees. So if there was an issue there of fees being an obstacle to obtaining and to exercising the right of access, it's already provided for. Last year, the report indicates that I think it was roughly $30,000 worth of fees that had been waived. So that provision exists in there.
Okay.
But otherwise,
Thank you.
Up until fairly recently, there was a $5 fee for the first 20 years that the Act was in place. Plus,
okay, I only have a minute left. My apologies for being curt. I do have to, as a lawyer, I'm hoping that you may be familiar with this case. But the decision in which the Supreme Court of Dagg versus Canada, the Minister of Finance in 1997, held that the overreaching dual purposes of the access to information are, one, to facilitate democracy by ensuring citizens have the information required to participate in democratic process, and two, to have politicians and bureaucrats remain accountable to decisions. Do you believe that the continued inefficiencies of the access to information are the result of the government prioritizing self-preservation over the democratic processes and accountabilities to its citizens?
The short answer is no, I don't think so.
Okay, those are my questions. Thank you.
Thank you, Mr. Green, and you were well under time, so appreciate that. We're going to move on to the 5-minute rounds now. Le prochain présentateur est Monsieur Gord. Monsieur Gord, vous avez la parole pour 5 minutes, s'il vous plaît.
5 minutes, Mr. Good. Thank you for being here. Your experience will shed light on our deliberations. If the access to information system is inadequate, could this cause some harm to Canadians or Canadian institutions? Of course, absolutely. This is the only legal way for a Canadian, an average Canadian, to obtain access to information under government control. It's the only legal way to obtain access to this information. And if we didn't have this right, if this system doesn't exist, then there would be huge harm. People can ask for this information for all sorts of reasons: medical, economic, tourist, industrial, civil suits. So absolutely, there would be huge harm. In your experience, when there's our CMP inquiry or investigation or some police investigation on organized crime that might have infiltrated their way in a department through obtaining a permit, for example, and they need access to information to find out what this list of Canadians might have been to obtain a certain type of permit. If it takes 4 or 8 years to obtain this information, well, this could definitely scuttle their investigation, right? Well, when you're saying if a person asks for a list of individuals, well, the list would definitely be inaccessible because such a list would contain personal information on individuals. And what if this request came from the RCMP? Well, the RCMP wouldn't obtain this information through this act. They would obtain it through the RCMP Act or their own access to information systems. They don't need to go through the Access to Information Act for the average Canadian. Question. So what is the normal reasonable delay for obtaining information? In an ideal world, what would be a reasonable delay? Well, for a relatively straightforward access to information request that is targeted and is focused, should maybe take 30 days. Now, is it 30 opening days or 30 calendar days? Give or take, let's say 1 month. Currently, 70% of access to information requests are responded to within 1 month. 70% of requests do obtain an answer within a month. So I think that's about right. But I would like a little bit more flexibility so that the 30 days are counted as 30 working days. 30 working days, I think, would be more reasonable. All right. What about the other 30% of requests where the delay is too long or unreasonable? Without naming names, have you seen some perhaps departments or some cases where the delays are years long? Yes, I've seen access to information requests that take 5 to 10 years to be answered. And the complaint I mentioned the other day, where information was asked in 2012, well, it took them 10 years to obtain this information. And the first thing that the commissioner did at the time, after 5 or 6 years of filing the request, is to ask us if we still wanted this information, if we were still interested. Well, the answer was, of course, yes. It's not because we were kept waiting for 6 years that we're going to just give up. No, we still want this information, even if it is 10 years later. Mr. Drapeau, some investigative journalists that asked for information to support some of their work, their investigative journalist work, who have to wait 6 years, well, that obviously can hamper their work and therefore the information that Canadians deserve to get. Well, look, it's not all the information that they ask that is held back. Sometimes it's just some types of information, for example, information that belongs to third parties or private companies who have their own access to information regimes and requirements. They can be, for example, airplane builders, food processors, and that will sometimes delay or slow things. Sometimes they'll refuse to provide information. They'll go to court. Sometimes it's a trade secret. So that's where you have delays. Thank you, Mr. Gourde. The chair's work is very easy when everybody stays within their time. Mr. Fergus.
Votre rencontre inaugurale plaisante, Monsieur le Président.
You're making it easy. Okay, thank you, Mr. Fergus.
Alors, tout d'abord, Monsieur Drapeau, merci beaucoup de votre présence aujourd'hui, puis aussi de votre présence.
Thank you, Mr. Drapeau, and thank you for your presence on access to information. I think you provide in-depth knowledge and expertise that is very useful to us.
Firstly, we all agree that 70% of cases are done properly, but we need to examine that 30%. And that number has increased over the years, especially since the increase of electronic uses. The Information Commissioner stated that sometimes requests are vexatious, as you mentioned in your opening remarks. She suggested that it is important for public service servants to know how to manage their emails, how to manage our inboxes. Because often, when we look at requests, well, the whole team will go through their inboxes, and there will be repetition in those emails. People will be receiving the same information 5 or 6 times, and there are better ways to manage the information. Given your experience, do you have any examples, international examples, where institutions properly managed their electronic data so that the access to information requests were made more simple? Answer: I think it is a universal issue. All requests don't have all of the same level of priority. And the public servant who is writing an email today doesn't think about the fact that the email will be a part of a chain of emails that will eventually be disclosed after an ATIP request. If it were the case, there would be a better discipline, I believe, and documents might be better managed. But that's the world that we live with, and we have to deal with it. With litigation, we see a chain of emails. A lot of information needs to be redacted, or especially if it is personal data. This increases the burden on staff because the volume of interpersonal communications is a lot more significant. Whereas before, a problem might have been somebody writing in cursive. But it is a problem that we have to deal with, and it creates an administrative burden. Question: if you were the information commissioner, what advice would you give to public servants on how to better manage their information? There should be annual seminars in the different departments, and share that one of their responsibilities with the Act is access to information, that they have a duty towards the public for access to information. So everything that they produce in their daily lives is accessible because they have a duty towards the public to respond. And they should not be offended by a request being sent in. Sometimes it is seen as being problematic, but that's life in a democracy. Canadians are paying for public servants' salaries, and they have the right to know. They have the right to have access to this information. This is something that was given to them, and this is a quasi-constitutional duty of public servants and parliamentarians to facilitate access to this information. And we haven't overcome this barrier yet. We would like to have as much information shared as possible. But the typical public servant sees it differently and wants to protect as much information as possible. This mentality doesn't exist yet in departments, that there is no problem with somebody requesting information. Thank you, Monsieur Drapeau, and thank you, Mr. Fergus. Mr. Villemur, 2.5 minutes. Thank you, Mr. Chair. You talked about Section 20 on commercial secrets. Is this section to limiting, considering the use, the current use of it? It is the section that was the most closely examined by the courts. So it was examined in all its forms. So within the Act, there is another Act that has to do with the information of third parties. If this information was given by third parties to departments, then we need to consult that third party, and they can respond, and they can request that certain information be considered professional secrets. Oftentimes, it can be disputed. So even if the public servant attempts to share information and did not share this information with a third party, well, then the third party can bring this to court. So it is an issue. And we have the necessary jurisprudence for this section, but it is a heavy section in its administration. Is it administrated too broadly? Well, the goal is to make information public, but we need to respect the rights of third parties and respect their privacy. I think that all courts have been able to find a balance there. Question: do you believe that enough government entities are subject to the legislation? Answer: there are some that fall through the cracks, but there aren't that many. There are public organizations like Radio-Canada and Canada Post who participate in this. The Governor General's office is not subject to this, which is something that I would examine. There are certain parts of the Senate and the House of Commons that are subject to the Act. I think that we have made improvements in the past 10 years. Thank you.
We have 2.5 minutes, please.
Thank you. I want to carry on in the spirit of the line of questioning of my friend from the block in regards to potential interference with the access to information process, that there are many limits to enforcement due to the confidentiality obligations where the information commissioner can only disclose information in the course of a prosecution or disclose to the Attorney General if there is evidence of a director, officer, or an employee of a government institution commissioning any offense against a law of Canada or a province. This excludes, however, ministerial exempt staff, consultants, and contractors hired by government institutions and former directors, officers, and employees of government institutions. Do you have any recommendations to address these limitations in enforcement?
Not at the moment. It's not something which I have, paid particular attention to. I've come to live with it and come to expect it, sort of, that some of those are excluded from disclosure. But if you look at the access regime as being allegedly universal, then I would tend to reach across to you and say that probably is a noble goal, but that goal ought to be argued here, if any place. I haven't seen any movement any place among myself or colleagues wanting to extend the right of access. Of course, the ideal would be that it be 100%, but nothing is this 100% coverage, whether it's within the court or even in here in the House of Commons and so on. So those at the moment are excluded, and that decision, whether or not to include them under the Act, belongs to Parliament, and and that's where I think it's fair and proper to be addressed.
You have recommended restructuring the Office of the Information Commissioner so that it only serves its mandated investigative functions. And are there any specific additional functions of the OAC that you believe are currently hindering the capabilities of the investigative branch significantly?
I think the
have to be
OIC
assured.
has got big enough of a job to investigate complaints, and there are sufficient number of them, about 6,000, and given its backlog, it wants to concentrate to the extent possible, greatest extent possible, all of its resources to be investigating these. And I don't see the need to provide the Information Commission with any additional task. Some of their predecessors have spent a significant amount of time and resources in presenting before this committee legislative changes and so on and so forth, which consume a lot of resources. Fortunately, we're beyond that at the moment. No, I think the OIC should concentrate all of its available resources to the investigation of complaint and try to reduce, if not eliminate, the backlog. This will serve the ultimate purpose of the Act.
Thank you, Mr. Drapeau. Thank you, Mr. Green. We're going to move to 5-minute rounds now. We're going to start off with Mr. Barrett from the Conservative Party.
Thanks, Mr. Chair. Thank you, sir, for joining us today. You've noted previously that, and as the topic of our discussion, the staggering delays in ATIPs can render them effectively useless. And while we have heard that, some may be perceived to be, though not found to actually be vexatious, or perhaps someone might say frivolous, it's evident that government uses tactics to delay the information so that it's perhaps less damaging to them. What's the remedy for that? And I can give you an example, sir. One access to information request I filed, very simple, has been over a year, and one extension was sought, and then the department just simply stopped replying to me in request for information on the status of that access to information request. So when there is apparent efforts by government to, or those working in government, to not provide information because it's unflattering to the government, what's the remedy for that?
Well, the remedy is within the Information Commissioner. You must have the ability to put a request in, and if your request comes as part of a pattern in a given department or a given subject, a given number of requests, then the Information Commissioner should have the ability to say, I'm going to be investigating as a systemic complaint. That subject or this department or requests from the specific users appears to be targeted for an absence of service. I would expect the Information Commissioner having the capacity, in fact, to react, not all the time, but to react when such a need manifests itself, to be able to allocate some investigative resources to try to get to the bottom of it in defense of the reputation of the access regime and also of your access rights. But at the moment, if you had the audacity to put a complaint to the Information Commissioner, you'll have to line up and wait 2 years or more before you have an answer, whether or not your request is founded and whether or not it has been turned down or not addressed for vexatious reason.
And we've seen that we've seen varying amounts of time that the information will take to be produced. There was an article about, and a well-known case, that it took 80 years to unseal RCMP records. The proponent articulating before his passing that he knew that he would be dead before he got that information. Is it reasonable that with a 30-day limit that we have these fulfillments being stretched for years and even decades for simple requests, and when the government is allocating tens of millions of dollars to the system, that there's no noticeable improvement to those who are exercising their right to request the information? What is the next step? What do we do now to address this? Because 2 years to make a complaint, 80 years to get your information, or a decade for them to do a simple keyword search, on what would easily be and a reasonable person would find are not confidential or sensitive documents. Like, what do we do?
My answer to your
minute,
questions,
Mr.
which I've
Drapeau.
covered in my piece published in the Mackenzie Laurier articles, is the OIC, first and foremost, should be given a 1-year limit to decide on the given complaint. 1 year. If within 1 year they haven't decided, they haven't completed, then the user has the right to go to court. And then you have a real outline to provide you, in fact, with a capacity to have your right respected. So go to court. As I said, in the States, there's no information commissioner. You put a complaint to the agency that to whom you first requested records, and if they don't respond to your liking, then you go to court. In Canada, you have to line up and wait until the information commissioner provides you with a report of its finding. That could be 6 years, 7 or 8 years. So hold the information commissioner to produce a report within 1 year. Surely they can do that. They should do this. And then if they don't provide you the records that you're after, then you have the ability to go to court in order to ensure that your constitutional right, quasi-constitutional right, is respected.
Thank you
Mr.
very much, sir.
Drapeau. Thank you, Mr. Barrett. We're going to move to the last 5 minutes line of questioning now, and Ms. Hepner, you have the floor.
And thank you to the witness for being here today. I want to go back to the point, and correct me if I'm misquoting you here, but I think you said more than half of the requests in the past year have been directed to immigration questions. And when we had the information commissioner here at committee, we heard that she was extremely impressed with everything that that department has done to improve the system, so that there's online portals where people can go to check their information rather than having to file an access to information request. She was very impressed, and I'm wondering what if you knew about this and what your thoughts are on how this might improve the entire system once those systems are up and running.
Well, last year, 145,000 requests being made basically brought the system to a halt. And accompanied, and I don't know if the significant increase also in complaints are also all resulting from the same, probably are. So now the Information Commission has got 10,000 complaints for last year. So something is amiss there, and I don't think that we need to have applicants to obtain their records or obtain whatever information they're after to go through the access regime. That wasn't designed for this. And what it does, in fact, it totally overcomes the bureaucracy within those departments and within the OIC, the capacity to respond to the other users. So something as a first priority, and that's what I've listed as first, is to make sure that that particular system to respond to immigrants and refugees and so on be done outside the access regime, and to the degree possible to have it as a positive response. In other words, you don't even need to ask for it. You can have access through this particular medium or this particular platform on request.
And so I understand that that is underway at that department. And what do you think overall the impact will be on the system?
Well, I think it will substantially reduce this sudden increase, both in complaints and requests, and have a beneficial impact. When I say it's been 52% augmented this year, there is also, before this year, there was still a high number of those. So by removing them from it, it will probably bring the requests, or the volume of requests, more in line with the ATIP staff, both at the federal institution and the OIC office.
Thank you. And I believe I understood that you said this government really opened up this system. There was a lot more access and more information available to Canadians. Can you talk about that a little bit more, and how opening up the system and making more information available to Canadians, what sort of impact that would have?
There was a number of institutions, CBC and Canada Post and a number of others, National Arts Centre, that became under the Act. The courts, many agencies of Parliament, House of Commons and Senate and so on, all became subject to the Act, CBC on top of that. So that was opening it up quite substantially to it. And many of these organizations have responded fairly, some of them not so well, and they still have a lot to learn. And we have reduced considerably the number of institutions that are still absent and still excluded from the Act itself. Also, over the past decade or so, the type of costs that the users would have to endure, which were certainly the $5 has remained, but in those days you had search fees and you had photocopying fees and so on, and sometimes those fees were in the hundreds and hundreds of dollars.
I remember that well as a journalist 20 years ago. So, and the cost would be prohibitive for a lot of news organizations, so you just drop the whole thing. This government also brought in Bill C-58, so that gave the Information Commissioner the power to make binding orders, like for related to access to information, the release of government records, time extensions, the language of access, the format of disclosed information. I'm wondering if you can comment on that legislation and what sort of impact that's had on the system.
I don't have any statistic to see how often and what guidelines has the OIC given to herself as to how to use this power. I have a sense, and it's an opinion, I have a sense that she's acted in a timid fashion. Maybe as it should, but timid. I mean, so that people could get to understand and basically to use that power is the last club that she has to use it. But how often she's used it, and are there some specific institutions that have been more targeted than others in some specific section of the Act, such as Section 20? Don't know. And her report doesn't provide with this kind of information. I wish it did.
Thank you, Mr. Drapeau. Thank you, Ms. Hepner. Mr. Drapeau, I want to thank you today on behalf of the committee and Canadians for coming before us. You've provided us with some valuable information. And I know that you're experienced at coming to committee. You came prepared and accorded yourself very well, sir. Thank you for being here.
Thank you very much.
Okay. So I'm going to suspend for a couple of minutes here while we move to committee business. Again, thank you, Mr. Drapeau. We'll be back in 2 or 3 minutes. Thank you. One more minute? Okay. Yeah. Order. We've got some committee business. As I mentioned to the committee last week, I did meet with the analysts and the clerk this morning to get a sense of, in the transition, where we're at. Now, there were a couple of issues that I think need to be dealt with. One was related to the travel motion that was passed by the committee. Now, the report has already been tabled in the House. So I don't necessarily see the need. I know, Mr. Villemure, that it was your motion, but I don't see the need for us to be traveling to either Denver or Palo Alto now that that report has been tabled. So I think what we should discuss here, and maybe Mr. Villemure, you can start us off, about not having that trip happen. So just a few comments, if you will, Mr. Villemure.
Merci, Monsieur le Président. En effet.
Thank you, Mr. Chair. Indeed, since the report has been tabled, I always thought it would be an interesting visit, but given all the work that we have done, I don't think, and we still have to do, I do not think it would be wise to maintain this visit.
I think we need to go to a vote on that. If there's unanimous consent of the committee to not plan that trip. Ms. Khalid?
Thanks, Chair. Chair, very respectfully, I think perhaps we should just table it for now, or unless we need to make a decision as soon as possible, or can we just keep it kind of on the back burner in case we do change our minds later?
Okay. My understanding is, in discussions with the company, that it's not even, what they do is not even germane to what the committee was studying. They don't do facial recognition. So tabling the trip with no purpose really, to me, doesn't make any sense. If the report's already been tabled in the House, this company doesn't do facial recognition, there really is no reason for us to even plan or have it on the books or table it in that regard. So that would be my preference would be just to get rid of it. That way it's clear to the clerks and the analysts in terms of planning that there is no plan for this committee to travel. So.
Sorry, Chair. Just respectfully again, I know that Monsieur Villemure had really presented this not in an effort to be specific about that company, but to kind of expose and to explore the bigger issue of facial recognition and of artificial intelligence. I'm not even sure if this company would be willing to let us go in, but I still think that perhaps we should keep our options open in terms of going to California to visit them.
So again, in the discussion that I had with the clerk, and the discussion, and maybe you might want to help out here, Nancy, the company has nothing to offer this committee in terms of what the study was. There's nothing that was germane to what it does, to what the study was. The study's completed and it's been presented, but you may have some more information.
Thank you, Mr. Chair. Actually, I was in contact with Palantir back in the time. What you have to keep in mind, it's not just about the company and the desire of the committee, but mostly about the fact that the House did accept and gave permission to the committee to travel. So the committee does not have to travel, but if the committee wants to do so, the committee can. Now, there are conditions, part of the motion of the House. So if the committee wanted to travel at some later time, then the committee would possibly have to redo the process and asking for a budget. But the committee could do it again later. It's just at this time, there are conditions to the motions of the House.
Yeah, and I think, I think we can revisit this later if we needed to. We don't have to deal with this now. If it's the will of the committee to ask the House for permission to travel, then we can do that at a later time.
Thanks, Chair.
Okay. So do we have unanimous consent then to annul the plans for the trip? Okay. Thank you. Okay, Mr. Green, I see your hand on Zoom. This is going to be new for me, trying to get everybody's attention here, but go ahead.
I do appreciate it. I just wanted to note something that happened, just to acknowledge the passing of Mr. Michael Dagg. I just wanted to go on the record today and acknowledge that passing. September 1st, he was somebody who obviously contributed to this committee, and I just want to take a quick moment just to acknowledge his passing. I just found out just now through the testimony of Mr. Barrett. Thank you.
Oh, okay. Okay, thank you, Mr. Green. I wasn't aware of that, but I appreciate you bringing that to our attention. Mr. Villemure, I have you next on the list.
Oui, Monsieur le Président, j'aimerais déposer une...
Yes, I'd like to table a motion that I will read. That, further to the commitments made in the testimony of October 17, 2022 on the use of public funds related to the Roxham Road crossing, the committee requires to receive from Mr. Pierre Gay, President of Importation Gay Limited, the Department of Public Works and Government Services, and the Canada Border Services Agency, the following documents. 1, the report on the use of the Hôtel Saint-Bernard. 2, the justification for invoking the national security exception for each of the leases and contracts. 3, the agreements reached between the federal government and Pierre Gay in the context of the crisis at Roxham Road. That these documents be submitted in both languages, official languages, in an unredacted format to the clerk of the committee no later than October 31st, 2022. And I'd like to speak to this motion. These are the documents which the witnesses already agreed to provide to the committee. And I already have a little amendment to this amendment to change the date and make it November 14th.
Okay. Thank you, Mr. And the clerk has just reminded me that technically you're not allowed to move an amendment on your own motion, but if it's okay and the will of committee members, then we can accept the amendment. And what is it? First of all, we need to hear what the amendment is, and then we can decide after that. Thank you.
The amendment was to change the date of providing the document from October 31st to November 14th.
Is in order. Any discussion on the amendment, Mr. Fergus?
Not on discussion on the amendment. I think 3 weeks works out. Excusez-moi, je vais m'exprimer en français.
Sorry, I forgot to speak French. My only concern is with the proposals in the motion. Mr. Villemure might be able to explain this to me. We had understood that not each entity provided for in the motion will be responsible for providing numbers 1, 2, and 3. It depends on which entity is best positioned to provide each one of the documents under 1, 2, and 3. So could Mr. Villemure just please clarify this aspect of his motion? That way it might not be necessary to amend the motion, but perhaps we can have a general agreement on these numbers 1, 2, and 3.
Correctly, that the spirit of what he's proposing is something that you can agree with. You just need clarification, Mr. Fergus, correct?
Well, Mr. Chair, it's going to depend on.
Well, let's find out.
But I feel
perfect. Let's find out from Mr. Villemure. And I have you next, Mr. Bear.
Okay. Discussing the motion by Mr. Villemure with the November date or the October date. So has it been accepted as it's? So are we tabling an amendment? Are we debating an amendment? Or are we debating the motion with the November date?
Yeah. So, Mr. Villemure, maybe you can provide some clarification on that, because my understanding is that you were looking for the October 31st date, correct?
La motion était déposée avec la date du.
Well, the motion was tabled with the date of October 31st, but to ensure that the documents are complete when they are produced, given our calendar and the fact that there is a non-parliamentary week in between, then perhaps we can give the people responsible for producing the documents an extra few days. So now to respond to Mr. Fergus, yes, of course. All the documents have to be provided by those who can provide them. So, for example, the report on the use of the Hôtel Saint-Bernard, I think Mr. Gay is the best positioned to provide this report. As for the national security exceptions, well, Mr. Gay is not well positioned to provide these exceptions. So the entity responsible for each of these different documents should be providing them, obviously.
M'assurer que tout le monde est sur le même long.
Yes, I just wanted to make sure everybody was on the same page.
And then Ms. Sachs on Zoom.
Thanks, Chair. Just wondering, are we've accepted the November 14th date? Is that? Yes, okay, all right. So I have 2 points that I just wanted to raise, and I know that Monsieur Villemure and I did have a conversation about this, and I really respect and appreciate the wonderful expertise and passion that Monsieur Villemure brings to the table. I really appreciate it. We heard from Monsieur Drapeau earlier today that 30 business days seems like a reasonable time to give to departments to be able to produce documents. In this instance, I realize and understand and appreciate, based on our conversation, Monsieur Villemure, that perhaps something a little bit more urgent would be necessary. So perhaps, if I may suggest very humbly and with a great amount of respect for the work that you do, that perhaps we can move it to perhaps the end of November to allow for those 30 business days. And then the second point that I will make, and I, again, respect and understand the reason why you've put this motion forward. I just think that there should be a little bit more clarity as to which witnesses are required to produce which documents. And I think you just as responded to Mr. Fergus that, for example, number 1 would be Monsieur Gay. Number 2 would perhaps be Public Works, and number 3 would also perhaps be Public Works. Would that be something that we are able to just outline specifically instead of saying, here are the witnesses, these are the documents, now go figure out what you think it all means? I just think that it would be great to have clarity as to who is expected to produce what documents, because in the event of vagueness or overbroadness, we know that nobody really responds to anything. So perhaps if that's something that you're willing to consider, to put a witness to each of the 3 listed items. Thank you. Those are my comments,
Okay,
Chair.
thank you, Ms. Khalid. Can I make a suggestion to committee members that we stick to the issue, if you're proposing November 30th, that we stick to the issue of November 30th to start, and then maybe circle back on some of the other concerns that you might have with respect to the witnesses providing documentation. So on the November 30th issue that Ms. Khalid, are you moving that as an amendment to, no? You're looking, right.
To see if Monsieur Villemure would accept it.
Okay. So I'll go to Monsieur Villemure before I go to Mr. Sachs on that. Is that, just hang on a sec, Mr. Villemure. Monsieur Villemure.
Thank you, Mr. Chair. The suggestion of 30 business days, from the witnesses we heard October 17th, so I think that by proposing November 14th, we're doing enough.
Ms. Sachs, on Zoom.
Thank you, Mr. Chair. And I'll just reiterate and be brief in saying we've just heard extensive testimony on how timelines set up for failure. And I think in this case, we, particularly Mr. Villemure, really does want to get these documents. And we would like to see, rather than a timeline that is cut too short, where then, as we heard in the testimony previously, there's just requests for extensions and requests for extensions, that if we actually propose a reasonable extension, as described by probably the leading expert on ATIPs and demanding for documents in this country at this time, then we will actually get what we're asking for. At the request of the chair, I won't dive into the clarity on each section. We can get to that afterwards. But yeah, I do want to see documents. And the other thing that I'd flag is just there's been a precedent in this committee of asking for unredacted contracts from private contractors. And that is a complicated precedent in terms of corporate privacy in agreements, and that just to expect that when we start to demand corporate contracts, that there is a resistance to do that. And you know, we want witnesses to come forward. We'd like to have companies be able to come forward in the future and discuss their work. But when we ask for unredacted private contracts, as a businessman, it does get complex. I know that procurement themselves said that they will not disclose those things. So just in an effort not to put the cart before the horse and to make sure that we get what we're asking for, I would ask if Mr. Villemure is willing to consider those, particularly the timeline at this time.
Okay. Thank you, Ms. Sachs. On the timeline issue, I think it's a lesson for all of us as well, so that we don't have to deal with this in the future, that anytime we request document productions, that we actually apply a date to it. In this case, there was discussion at the committee, from what I understand, but there was no actual date. And so what Mr. Villemure is trying to do is trying to provide that date. And he's quite right in the sense that it was October 17th that the meeting took place. He's requesting November 14th, which means we're close to that 30-day window. But just for the future, we need dates, and I just want to be clear on that. So, Mr. Villemure, I saw your hand up.
Thank you, Mr. Chair. With regards confidential information of third parties, it depends on what they are ready to share. On October 17th, Mr. Gay said that he would be ready to disclose all information, so I don't know how it would apply in this situation.
Barrett?
Thanks, Mr. Chair. So, with respect to just the timeline, November the 14th, I think that's a lot of time. That's 3 weeks. But then we, depending on the volume of documents that we're dealing with, it could take some time in translation. I understand that that's going to be a bit of a bottleneck that we're dealing with, and then a question for the clerk through you, Mr. Chair, on if documents requested of the government, if the expectation is that those come translated. So I'm not clear on that. If when we give a production request to or order to the government, if that motion is passed and it's X date, November 14th, do they come from the government translated on the 14th? Is that the expectation? Whereas if they're coming from a private business, they're likely to provide them in their working language, and then translation would engage. Is my understanding correct on that?
That's a question I'll ask the clerk. It's a good one.
Thank you. The expectation usually is that they are provided right away in the 2 official languages to us from the government.
From the government.
Private entities, they don't have to provide the translation. We do it, but when it comes from departments, usually the expectation is that they will provide to us already in the 2 languages.
Yeah, so just to follow up on that, thank you very much, Madam Clerk. We're dealing with 3 weeks, which is 4 weeks after that initial testimony. As Mr. Villemure rightly pointed out, Mr. Gay did say at that time he was prepared to, provide us with that information. So we're also going to, for lack of a better word, lose a week in translation, likely. And I'd invite you to correct me if I'm wrong on that, Mr. Chair. So we wouldn't even get to public discussion or distribution amongst committee members of those documents until the 21st of November. So that's a lot of water under the bridge between now and then. So I wouldn't have an appetite to go past the 14th of November. Thank you.
Okay. Thank you, Mr. Barrett. Ms. Khalid.
Thanks, Chair. I really appreciate that clarification. That was an excellent point by Mr. Barrett. But I still respectfully feel that as we are continuing this ATIP study, there is no time that is lost. We all unanimously voted at the last meeting to, was the last meeting or the one before that, to end that study and to not continue with it. So I don't see there being a sense of urgency with respect to collecting these documents or to putting out a report. In fact, if we all felt that there was more here, I think that we would not have unanimously agreed to end that study. So perhaps, just in the interest of not putting undue pressure on Monsieur Gay and to ensure that departments are able to get us the documents that we need, I would propose that we delay the document request till the end of the month of November, whatever is good for Monsieur Villemure on that front.
Okay, so just to be clear, are you moving that as an amendment to Mr. Villemure's motion?
No, sir, I'm not. I'm again very humbly suggesting to Monsieur Villemure if perhaps he will take that as a friendly amendment for his main motion.
Okay. So I'll go to Mr. Villemure in a second, but on the issue of the meeting itself, yes, you are correct that the committee decided no further studies were required, but the document request is still in play. So what Mr. Villemure is trying to do is just to put a date to it. So I hear what you're saying about November 30th. I'll turn it over to Mr. Villemure to see if he will accept that, and if not, then we'll either have further discussion or we'll agree to the date.
Je ne peux pas.
I cannot accept this date because I don't want to assume that someone is not able to respond. The request needs to be made, and we need to receive the documents. And if there is an issue, then that person can send in their issues, but we shouldn't assume their answer.
Again, just so that I'm clear, you're proposing November 14th, correct?
Yes.
Okay. So that is the proposal that's on the table right now. Any further discussion on that? Okay. So, Mr. Currick, do you have anything to add on the date?
No, I think that I know the testimony referenced in the discussion in the first hour of this meeting talked a lot about reasonable deadlines, and I think that one should acknowledge that this request was made during the testimony that took place at the last meeting. When it came to the motion that was passed, it was, I think, made very clear to this committee that it was to adjourn debate on the study pending the production of some of the very, very relevant documents that allow this committee to chart a path forward. So getting these documents, I think, is vital for the future work of this committee. There's been that request was made at that meeting. I would hope that it would have been taken seriously at the time. Certainly, that would suggest maybe a bigger issue if it wasn't. However, I think Monsieur Villemure in his motion has rightfully said, as we faced some challenges in this committee before, by not having absolute clarity in things like document requests and whatnot, and appreciate the discussion around timelines and translation. That's all very important. But I think it's quite reasonable to expect these in a time frame that would allow us to allow the committee to make a determination as to a path forward, and then the next steps, of course, whether the committee is satisfied and the report is produced and things move on, or if there is something that requires more digging into, then it's up to the committee, and as being each of us around this table, collectively being able to determine that path forward. So, being reasonable, we shouldn't expect that the maximum deadline is always what's required, and I would, as I mentioned, certainly hope that the request was initially taken seriously. So this information should be available within what could be an expeditious manner.
Thank you, Mr. Currick. Ms. Khalid.
Thanks, Chair. I think, over my past 7 years here as a parliamentarian sitting on various committees, that departments do indeed take committee requests very seriously. As they should. And I think that we heard directly from the departments, the witnesses, that they would be providing the documents that we have requested. My only concern is that I just want to make sure that we give them reasonable time to be able to make those productions. So, for example, Monsieur Gay, who's a private entity, if we're asking him to produce a report on the use of the Hotel Saint Bernard, does he have that time? Does he have the time to translate it? Do we have the ample time to translate it before the committee circulates it? So proposing the date to be a little bit further into the month has nothing to do with giving more leniency to the departments or to the people that should be fulfilling their promise to provide the documents that they have indeed already promised this committee. My concern is the practicality of it, to ensure that we are not putting undue pressure or undue timelines or unreasonable timelines on people that may not be able to meet those deadlines, because I think that I don't want to put our witnesses in a position where we kind of force upon those unreasonable timelines on them. But having said that, I realize that the committee is not unanimous on moving it till the end of November, and I understand and appreciate with Monsieur Villemure's leniency on November 14th that we're okay to go with that. But I do think, though, that we do need to clarify specifically what documents we are requesting. So, for example, the report on the use of the Hotel Saint Bernard, if that is specifically being expected from Monsieur Gay, then I think that the motion should say that. I don't anticipate that any of these witnesses would be able to provide all three or any one, or I just think that it's better to have clarity. So perhaps as we work through this motion, perhaps we can just iron out and clarify exactly who do we expect what documents from, Mr. Chair.
Okay, thank you, Ms. Khalid. So are we okay? Are we clear on the 14th then as being the date? And then we can move on to this other issue? Okay, no objection, Zoom, we're good? Okay, so it's the 14th then, Monsieur Villemure, and then I don't know how we're going to propose moving to some clarity here. Perhaps, Mr. Villemure, you heard some of Ms. Khalid's concerns. Is there a possible way to address those?
J'ai donné l'exemple tantôt.
I gave the example earlier. The people that we are working with are not dumb. I wouldn't want to put too many details and restrict anything when I believe it's clear enough.
First point is that his motion is clear enough. Any other questions or discussion on that? Mr. Fergus, I see your hand.
J'apprécie.
I appreciate my honorable colleague, and I appreciate that he changed the date in his motion, but I believe that things should be a little bit more specific in the motion. If I can have a few minutes, I would like to propose an amendment to the motion just to specify who would be responsible for what documents. And I just want to be certain to not take away from Mr. Villemure's motion, but I just want us to state who will be producing what documents, and that's all. That's my proposed amendment, but if you can give me just 2 minutes, I would be able to jot down a quick amendment in both languages.
I'll give you 2 minutes, Mr. Fergus. There is some other business that we need to discuss as well in terms of a work plan going forward. I was hoping to get to that under committee business, but I'll give you 2 minutes. 2 minutes.
I appreciate that.
Okay, thank you. We're coming back. Mr. Fergus, you've had a couple of minutes to think about this. You have the floor, sir.
Modification va être précisée.
So I suggest that we amend Mr. Villemure's motion as follows by adding at number 1 at the end of the sentence, open a parenthesis and write Mr. Gay, close the parenthesis. Then after number 2, at the end, open the parenthesis, PSPC in English, SPAC in French, close parenthesis, SPAC, Service Public Approvisionnement Canada, SPAC in French, and at number 3, at the end, open the parenthesis and say RCMP or IRCC, and in French, GRCC ou IRCC, close the parenthesis. And those are my amendments.
I would suggest on number 3, which you haven't included in this, would be the potential of the Canada Border Service Agency as well, not just the RCMP, right?
Excuse me. I mean, perhaps you're right. Actually,
Okay.
You're right. I would thank you for that. I would
Okay.
take out RCMP and I would replace it with.
I would do
Canadian.
both, perhaps, right? Both. Mr. Villemure, I saw your hand up there. I don't know whether you were addressing the same issue or not, or
Indeed, I would also add the Canada Border Services Agency.
be clear, Mr. Fergus, if your amendment, as you propose your amendment, you've got Mr. Gay as number 1, PSCP, SPAC as number 2, and then the third one would be the RCMP, GRCC, and then my suggestion is that you add the Canada Border Service Agency in there as well.
Actually, sir, I would suggest that we take out RCMP and replace it with CBSA. That was actually, I think, it was just based on the testimony, it was CBSA and IRCC that interacted with Mr. Gay. Or
Okay.
through them, they were the clients through which PSPC had spoken to, but they established what Mr. Gay is looking for, what Mr. Villemure is looking for, number 3.
So just give me a second here so that I can ask the clerk a question. Okay, thank you. Mr. Fergus, I need you for a second, if you don't mind. So initially, your proposal, just so that I clear, I might have got lost in translation, was it RCMP or IRCC that you were looking for initially, that you proposed? Yeah. Okay, okay.
But I would like to change that, if that's possible, to CBSA and or IRCC.
IRCC. Okay.
That was the right one.
Okay, thank you. Okay, so, wait, Mr. Fergus a proposé un amendement.
Proposed an amendment to the amendment. Mr. Villemure, I wanted to add something which I believe is important. I'm all right with numbers 1 and 2, but at number 3, we should also add the ASFC, the Border Services Agency, because they acted, PSPC acted under the Border Services Agencies, under the instructions of the CBSA.
Right. So just then, Mr. Villemure, the Canada Border Service Agency was there, but you're saying that you want the SPAC to be included in number 3 as well?
Selon M. Fergus, il était inclus.
So according to Mr. Fergus, the PSPC was already there. So he has said PSPC? No? No?
IRCC and the Canada Border Service Agency. Those were the two things that he wanted there.
Le troisième, c'était?
IRCC,
And what was the third one? So IRCC, Immigration, Refugee Citizenship and Immigration, and the Border Services Agency, CBSA in English. So on the number 3, IRSCC and CBSA? Okay.
The other problem that we have, just so that we're clear, is in the preamble. Mr. Gay's fine, Department of Public Works is fine, Canada Border Service Agency is fine, but there's no inclusion of the IRCC there.
Chair.
Yeah.
Wouldn't it make sense if we're adding witnesses to each of the 3 points that we just take out the list from the top, just to say that the committee requires to receive and then colon 1, 2, 3?
That actually makes sense to me. Okay, so if we remove, Mr. Villemure, if we remove the name of Mr. Guy, remove the Department of Public Works and Government Services, and then the Border Agency, if they are reflective in 1, 2, and 3, that should be enough to indicate to the government and Mr. Gay what we are asking for in terms of these documents. If you're okay with that, and we've included the IRCC in there as well in number 3, so.
Yeah, mais Mr. Barrett avait un
It seems fine to me, but Mr. Barrett wanted to say something. I'd like to hear him before giving my final consent. Thank you, Mr. Chair.
We've got the proposal from Mr. Fergus is to have Mr. Gay respond, and Mr. Villemure had commented earlier that he didn't want to be too restrictive, and so now that we are prescribing who is providing which documents, I would be very interested to see on number 1, because this is a point of contention, and we heard during our last meeting that there was disagreement on the use of the hotel, on when it was being used and what it was being used for. And so the government had offered that the hotel Mr. Gay had offered that the hotel was being used. So I would like for number 1, where in parenthesis Mr. Fergus had proposed Mr. Gay, and then close parentheses, I would propose that it say Mr. Gay, were we using commas or ands in between? So I would like to additionally request that the government provide a report on the use of the hotel. So I don't know which agency would be best suited, but again, I appeal to everyone's better angels that that they'd be prepared to provide that information unless our wise clerk or analysts could perhaps prescribe who should be included there. But the objective is that we're getting a response from both parties on the use.
Yeah, Mr. Barrett, and I know I saw your hand, Mr. Fergus, but what you're proposing would be a sub-amendment to Mr. Fergus's amendment. So if you want to be very clear as to what you want, whether it's the government or a department of government under that section 1, then I would ask that you be more specific on that, okay?
All of the departments can get back to me,
Right.
but let's.
You want to just leave it at the government, or do you want to be specific to a department?
So I'm not sure if we're able to get guidance based on the evidence that's been gathered so far from the analysts, Mr. Chair, if that's appropriate, on who would be able to provide us that information. I don't imagine that's outside the scope of what the Library of Parliament can advise us on right now while this is live. And yes, I would like to propose it as a sub-amendment. And in keeping, and this is in keeping with what Mr. Villemure said, but to be clear, although I was being clever with my my response that we'll hear from all of them. I would only like to hear from the department who is most likely to be able to furnish us with the information in a timely way.
Okay, fair enough. Okay.
So
Thank
is
you
that
for-
is that something the analysts are able to provide us with, or?
Perhaps provide, I was looking earlier at the blues because the official transcript is not out, and the question when the request for the report for the use of the hotel was made, it was Mr. Paulus who made the request, and he made it to a representative of a PSPC, who then in his answer, I have it in French, but in his answer referred to CBSA, so that's the only inkling I have that it perhaps would be CBSA, but...
So I kind of like Ms. Khalid's suggestion there that we go for an and/or, right? Monsieur Guy and/or PSPC, Canada Border Service Agency, like.
Mr. Chair, if I may, so I would like to hear from Mr. Gay and PSPC and/or CBSA. So we only need to hear from one department, but I want to hear from both the business, both from the private entity as well from the department. So is that clear enough? So it would be a sub-amendment that number one, the report on the use of the Hotel St. Bernard, open parentheses, Mr. Gay, and CBSA and/or PSPC, close parenthesis.
Thank you.
Thank you.
On the,
Thank you for
on the sub-amendment, Mr. Fergus. Reasonable request?
You know, so I don't think it's going to make a material difference, but I don't want to be eating my words because we've made it we've made the material difference or distinction between the two. I think it's just easier to go with your suggestion, Mr. Chair, or I should say, I guess it's Madam Khalid's suggestion that and/or works better than and/or. So we're getting into the weeds here. I like the idea. I like the way we've been working. I think collaboratively. I think there's a way for us to do it. But
well, I think we all want the same thing. We want to make sure we get the most accurate information, and I think by proposing this, actually puts us in a better position to get the information that we're seeking. So from either or and/or Mr. Gay, or PSPC, and Canada Border Service Agency. So
again, the only reason why I think it was good with Mr. Gay, and maybe Mr. Villemur heard the same thing that I heard and I think we all heard it, is that Mr. Gay had pretty much offered that he was going to provide us with that information. So I thought that was, let's just get it, and no one says that there's commercial confidential reasons why they can't release it. If he does it, then it's great.
And if he doesn't?
Well, he offered to do so before.
I know, but if there's more information that's required, I think, from my perspective, what's being proposed here is that there may be other information that's available. That's the only thing that I see as being plausible here by asking the other two agencies. Please. Yes.
Just looking again through the blues, and in one of his response, Mr. Stéphane Derry specified that the hotel was leased at the request of CBSA.
Okay.
So I think that would be probably the party to ask that.
Mr. Gay or CSB and/or CBSA. Would that work for Mr. Barrett?
You've got the amendment on the floor.
I'm happy to amend my amendment to Mr. Villemur's motion to concord if Mr. Barrett would agree if it's Mr. Gay and/or CBSA.
So if I may, I would like to hear again, like from Mr. Gay and the government. It doesn't need to be and/or an additional agency. I accept that it's CBSA, but ultimately, I'd like to hear from both. From both.
Okay. Mr. Fergus?
Then I'm fine with it.
Okay, perfect. Okay, so So we've gone through, so that deals with the sub-amendment. We're on the, are we on the sub-amendment or the amendment? I'm losing. Right.
We should probably go to a vote
Okay.
to respect the House motion unless there's agreement of everybody
Agreed.
to adopt it.
Okay, so no further debate, or should we go to a vote on this? Yes.
Thank you. So it's the vote on the sub-amendment by Mr. Barrett. Mr. Baines.
Voting yes.
Thank you. Monsieur Fergus.
J'approuve la motion. Le sous-amendement.
Parfait. Miss Epner.
En faveur.
Miss Khalid.
I'm in favor.
Miss Sachs.
In favor?
Yay.
Wait.
I vote in favor.
Mr. Green.
In favor?
Thank you. All yeas, Mr. Chair.
Okay, thank you. So the sub-amendment carries. That leads us to the amendment. Now, just let me clarify with the clerk here, because we did deal with the sub-amendment, which changed what the amendment was, because the amendment was,
Amendment was to add CBSA,
CBSA.
after Mr. Gay.
okay?
Now we
Perfect.
SPC en français.
Oui.
Peut-être tu me mêler.
Okay, so we're on Mr. Fergus's amendment here. Any further discussion on that, or can we go to a vote on that?
Sorry, Chair. Just if we can just read out what it looks like in its form, please.
Go ahead, Nancy.
I can. It's
Yeah.
very messy, but I will.
It's your writing.
So it will be that further to the commitments made by the testimony of October 17, 2022 on the use of public funds related to Roxham Road crossing, the committee requires to receive, and now we have agreed that if we add notes to 1, 2, 3, then we're going to strike the part after receive. So then it will be that the committee requires to receive, 1, the report on the use of Hotel Saint-Bernard, parenthesis, Mr. Gay, and CBSA and or PSPC. 2, the justifications for invoking the national security exception for each of the leases and contracts, parentheses, that would be in English PSPC, en français SPAC. 3, the agreements reached between the federal government and Pierre Gay in the context of the crisis at Roxham Road. And this one would be CBSE and or IRCC. That these documents be submitted in both official languages in an unredacted format to the clerk of the committee no later than November 14, 2022. So that is the final motion, what it would look like. What you're going to be voting on right now is, do you want to strike the part after requires to receive? Do you want to strike from Mr. Pierre Gay, blah, 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 and then add the text in between parentheses at point 1, 2, and 3?
Okay.
Is that clear?
It's clear to me. I see, Mr. Villemure, your hand is up.
J'étais jusqu'à maintenant sous l'impression qu'il y avait travaux publics et le Border Agency également.
I was under the impression that at point 2 there was Public Works and the Border Services Agency, because Border Services Agency acted under the instructions of its client, and so if we don't include Border Services, we will probably get a non-answer.
Okay, in the notes that I've taken on my sheet, it was SPAC, and that the border agency was included in number 3, not number 2. Am I correct in that?
Maybe the analyst can make sure, but my understanding is that SPAC en français, c'est Services et Approvisionnement Canada, puis c'est une section de travaux publics.
SPAC, c'est Services publics et Approvisionnement Canada, so Public Procurement Services.
Oui.
Ben, étant donné qu'on est sur les détails,
But because we're going through the details, Public Works works on behalf of a client, in this case the CBSA, and if they are not included, well, we won't be receiving all the documents that we want. It will be incomplete. It's the same as point number 3.
That's a fair point. I don't think, look, if the committee is okay with that, I would propose that we include it. Mr. Fergus, you want to make an amendment on that, or?
I was going to suggest, Mr. Chair, just to be precise, could we just do the and/or? And the reason why is I just want to get the information, and move on.
Is it correct, sir?
So rather than doing the and, which we have to wait for both, and then somebody's going to include one word, not include another, just and/or, and we get the information so that we can move on.
si nous recevons l'information complète, je n'ai aucun problème.
That's fine with me as long as we receive all the information that we want. It's part of the criteria of the motion. Is that all right?
And/or in that, we'll take that as an amendment. So we're voting on the amendment to the motion. Can we have a vote on that, please?
Certainly. So do I have to repeat the amendment, or are we good with what I said?
I think we're good.
Perfect. So the vote is on the amendment by Mr. Fergus, and we'll go with Mr. Baines.
Voting yes.
Thank you. Monsieur Fergus.
L'amendement.
Ms. Hefner. Oui. Ms. Khalid.
Yes.
Ms. Sachs.
Sorry, yes.
Thank you. Mr. Barrett.
Yes.
Monsieur Gourde.
Oui.
Mr. Kurek.
I vote yes.
Monsieur Villemur. Mr. Green.
Je vote pour la motion.
Oh, yes, Mr. Chair.
Okay, merci.
Thank you, Nancy.
We've got the amendment passes. Now we're on the main motion as amended. Any discussion on that? Seeing no discussion, either in the room or on Zoom, we'll move to a vote on that. Yes.
Thank you, Mr. Chair. So the main motion as amended, Mr. Baines.
Yes.
Monsieur Fergus.
La motion.
Ms. Hefner.
En faveur.
Ms. Khalid.
In favor.
Ms. Sachs.
Yes?
Mr. Barrett.
Yes.
Monsieur Gourde.
Oui.
Mr. Kurek.
I vote yes.
Monsieur Villemur. Mr. Green.
En faveur.
Thank you. All yeas again, Mr. Chair.
Okay, thank you, Madam. Missing that already. Okay, thank you, Madam Clerk. So the motion as amended passes. Before, there are a couple things that I need to discuss just quickly with the clerk. Yeah. So just for the update on the committee, in terms of going forward, I met again with the work plan. We've got 3 witnesses confirmed for the continuation of the access to information and privacy study. The other thing that I need to discuss, there's a draft report that's been completed, hasn't been brought to the committee on the RCMP device investigation tools. That's ready. It can be studied next week. For 2 days, Monday and Wednesday, and of course we have the constituency work week after that, and then we'll have to determine the 14th and 16th what we're going to do. But the plan this week is to continue with the access to information privacy study. We're all good? Okay, that's it. Thank you so much, everyone. Thank you for your patience. As a new chair, meeting's adjourned. No, I was no. Aye.